First, trapping and hunting with dogs are a management tool that the department uses to reduce and help us resolve wildlife conflicts. And it can sometimes be challenging for biologists to focus on issues that have so little effect on wildlife. And I'm talking about trapping and hunting here. Priorities that have been imposed on us have been promoted by a very dedicated and sophisticated group of animal rights advocates. And the department sincerely believes that they represent a minority view in Vermont. I know that there have been some really troubling and tragic experiences that people have had with hunting incidents, not only trapping, but hunting in hounds. And I don't want to belittle that. That's a fact. You've heard some of those stories. Unfortunately, we cannot eliminate risk with regulation. And the biggest risks associated with trapping are violations, people who are trapping in violations of the rules, and nuisance trapping. The commissioner, on behalf of the department, was willing to engage in this process because we want to start working cooperatively with our partners, with the legislature on priority issues.
And then like I said, I wanted to offer a motion or ask for a motion to include a piece around landowner permission for folks with hounds going on property, right? And we'll do that after we have questions and answers.
Area. What's the logic of allowing underwater trapping within that 50-foot boundary?
You know, the scent of whatever the bait is and the risk sort of associated with that is really reduced. And that was our thinking.
I've been in correspondence with some hounders in the Troy, North Troy area. And I guess one of their concerns is this limited number of permits of 100. Again, I think with the investment and the time that a lot of these hounders put into their dogs and equipment and so on, I would hate to see that their opportunity not be there with that 100 number limit. Right?
So that number was somewhat random in a way. So I do think that once we have a better handle on how many permit applications we get, you know, we could conceivably come back to the legislature and ask for some adjustments.
Okay, thank you.
Senator Bray.
Even so, as a chair of the committee where the bills passed that led to the rulemaking that we're looking at today, when I review the rule, I see areas in which the rule succeeds and other areas where I think it fails to meet legislative intent. And I would like to offer a motion to reflect this split assessment. So more formally, Mr. Chair, I move that we approve Rule 23, P15, 10 VSA, Appendix 44, fur-bearing species, with proposed modifications submitted by the Fish and Wildlife Board in correspondence from Catherine Gessing dated November 14, 2023, and except in the case of a portion otherwise objected to. I think there's some specific elements that, to the best of my assessment, fail to meet legislative intent. So I'm moving that we approve the rule overall and then visit any kind of objections that any member of the committee might want to raise. I myself have two in mind.
Thank you, Senator Bray. Thank you, Representative Higley. So under the APA, LCAR can object to a rule or a portion of a rule. And so what Senator Bray's motion is doing is setting up to say, overall, we approve the rule, except there might be portions of the rule that are otherwise objected to. If the motions for those objections, if they're made and they carry by a majority of the members of LCAR, they're all present, so it's a majority of you that are here, then the adopting agency here, the Fish and Wildlife Board, needs to respond within 14 days. And then after that 14-day window, LCAR is in a position where it can either withdraw the objection, modify the objection, or move to file the objection in certified form with the Secretary of State's office. And if the objection is certified, then it basically attaches a blemish to the rule. And if in the future the rule is adopted, it doesn't prevent the board from adopting the rule. They don't have to make any changes in response to the objection or the certified objection. If there's litigation in the future, the burden of proof would shift to the board to prove that the basis for the objection was not there. And you heard Senator Bray say that it was on the grounds of legislative intent. So if there is a certified objection to a portion of the rule on the ground that it is inconsistent with legislative intent, and there's litigation, the board would need to have the burden of proof on there being consistency with legislative intent there. There is a moratorium in Section 2, subsection A. A person shall not pursue coyote with the aid of dogs, either for the training of dogs or for the taking of coyote, except that a person may pursue coyote with the aid of dogs, and then there are some instances when they can. And then subsection B says, this section, that moratorium, shall be repealed or the moratorium lifted on the effective date of the Fish and Wildlife Board rules required by Section 3 of this Act. So it's the effective date of the rules as required by Section 3, and that's significant, lifting the moratorium. Section 3 establishes some minimums for what the rule needs to do. So Section 3, subsection B says, the Fish and Wildlife Board shall adopt a rule regarding the pursuit of coyote with the aid of dogs, either for the training of dogs or for the taking of coyote. The rule shall include at least, so that minimum, the following provisions. So I think it is arguable that if the rule is adopted and becomes effective and it doesn't meet at least those following provisions, then the moratorium is not lifted because Section 3B, and then there are a number of those minimums, have not been met. However,
The motion is designed to approve the rule overall and recognizes the very work you're talking about. And that said, there are instances of provisions in the rule that, in my best judgment, don't meet legislative intent. So I'm trying to offer a motion that allows us to recognize portions that should move forward and then identify elements that, in my assessment, we merit objection.
Okay, we have a motion from Senator Bray. All those in favor, please say aye. Raise your hand so we can. Aye. Those opposed? Thank you. Motion passes.
I'd like to make another motion.
Okay.
And these are things we have discussed. So I move that we object to portion 4.15, trapping setbacks, that accepts from the setback requirements traps set in the water or under ice on the ground that is contrary to the intent of the General Assembly to exempt traps set in the water or under ice from setback requirements. There's a provision that you had asked a question earlier about the setback, not including the setback requirements for traps set in water and ice. There's the rulemaking requested didn't specify or call for any such exemptions that it was. So therefore, seeing that it's contrary to legislative intent and therefore objecting to that particular point in the rule.
So you're Motion is to remove the exemption of the underwater traps within the boundaries, the 50-foot boundaries following a trail.
Yeah, so our lawyer can help get this legally correct, but I'm not, all I'm making in this motion is a motion to object to that particular provision. The response of any party to the objection, it's beyond what I know of Ohio.
So if you move to object, the majority vote of LCAR, and then it's certified, there would be that sort of blemish on just the portion of section 415 on trapping setbacks related to accepting from, and this exactly goes to your question from earlier, accepting from the setbacks, the traps underwater and ice. So if you look at the language of section 415, no foothold traps or body gripping traps shall be set on or within 50 feet of the traveled portion of, and it lists the places that it applies to, unless set in the water or under ice. And that phrasing, unless set in the water or under ice, is in both 415A and 415B. So Senator Bray has objected to that small portion of section 415 in both A and B, the unless. So that would be saying that the rule can still be adopted just as it is on the page with the exception. But if there is litigation, the burden of proof would shift to the board to say that it is consistent with legislative intent, because that was the ground that Senator Bray's objection was under, that it is consistent with legislative intent to accept from the setbacks traps that are in the water or under ice. All LCAR can do is object. And then what happens after the objection happens after the objection. You don't know if there's ever going to be any litigation. You don't know if the board's going to adopt the rule. You don't know if in the next 14 days the board's going to propose a modification. It is very, very speculative what happens based on the objection and telegraphing into the future if you certify the objection, if there is that blemish on the rule. So all Senator Bray's motion is doing is that first step of LCAR objecting to a portion of the rule.
Okay, we have a motion and Senator Bray regarding setbacks for traps in water under ice. All those in favor, please say aye. Raise your hand.
Aye.
Those opposed? Okay, thank you very much.
Mr. Chair, if I may,
Senator Bray.
I'd like to offer a second motion specifying another grounds for objection. So I move that we object to section 3.6, definition of control of dogs, and 4.20, taking coyote with 8 of dogs, on the ground it is contrary to the intent of the General Assembly to allow the taking of coyote with 8 of dogs unless there is a required means of controlling dogs that sufficiently minimizes the risk that dogs pursuing coyote will enter onto land that is posted against hunting, enter onto land where pursuit of coyote with dogs is not authorized, harass or harm people or domestic animals, and cause other unintentional damages to property, to people or property.
All those in favor, please say aye.
Aye.
Opposed? Thank you. Representative Bongartz.
2 objections I would like to raise.
Floor is yours.
The first one is I move that we have section 3.20, the definition of trapping on the ground that is contrary to the intent of the General Assembly to add the word hunt to the definition. It has always been hunting, fishing, trapping. The department, I understand the department takes the position that they have always considered trapping to also be considered hunting. But hunting is constitutionally protected. It's not clear that trapping is, and they take the position it is, and I understand that, but this is an issue that should be decided by the legislature, not by the insertion of the word, if you will, arbitrarily by the department. It's nothing that's called for in the legislation. It doesn't do a thing to help anybody understand what the rules are when you trap. And I believe it's simply contrary to legislative intent. And so I think it's an encroachment on the authority of the legislature.
On the motion from Representative Baumgartz, all those in favor, please say aye. Aye. Opposed?
No,
Thank you. You got a second
I have
one?
a second. I move that we object to section 3.14B, portion of the definition of public trail on the ground that is contrary to the intent of the General Assembly not to include all trails where persons may reasonably be expected to recreate.
None. All those in favor of the motion, please say aye.
Aye.
Those opposed?
no.
Okay.
I do have a question.
Yes.
Given that 14 days is not very far from now, and there's a holiday in between, and we're working with a board, is there a possibility that we might be able to ask for an extension?
Okay, so under the APA, section 842A2, the agency shall, within 14 days after receiving notice of the objection, respond in writing to the committee and send a copy to the Secretary of State. In its response, the agency may include revisions to the proposed rule or filing documents that seek to cure defects noted by the committee. And then under the list of procedural failures, failure to respond to an objection of the Legislative Committee on Administrative Rules is required in section 842 of the title, prevents a rule from taking effect. So I don't think LCAR can not withstand statute to give you an extension on the 14 days. But if you don't respond, you can't adopt the rule. And I think there's sort of an understanding, not speaking for the decision makers, that they would probably like to hear the response before certifying the objection or not. I will say that if you don't respond at all, you can't adopt the rule. So it sort of has like a self-affecting penalty of if you don't respond, whether it's within the 14 days it's required in statute or at all, can't move forward to the next steps of the rule.
Thank you. Yeah.
And I, if I may speak for the committee, I think we want to see a response. We don't want to preempt that response.
And this is the sort of pattern that has been followed in the past when LCAR has objected to a rule, is I, on behalf of the committee, as your committee counsel, will send a letter to Catherine. It will go out today that gives those 4 objections. So if you didn't write them down, it will include the sections and the grounds upon which it was objected to. And that will start the 14 days. That'll be noticed. If any of those objections are subsequently certified, the way that it's done historically is the chair of LCAR will send a letter notifying the Secretary of State of the motion to file the objections in certified form. So
It's my understanding that the objection that has been approved by the board related to control of dogs would mean that the moratorium would not be lifted.
Not to belabor this, but again, I think that particular provision is in essence a de facto ban on hunting coyotes with hounds.
I want to say thank you to everyone that's participated in this process.